Good morning, everybody. Monday morning. I assume most of us are off to work for another week. It's a nice, bright, sunny day here in Irvine. Thank goodness. I'm getting tired of the rain, as I guess a lot of you are. Uh, Maybe I can wash my car this time and it'll stay clean. Uh, in any event, welcome back. This is for the second half of my lecture for week 4. And a couple of items, administrative items, before I start laying out the law of intellectual property. Uh, First of all, the research paper proposal I would like to have right away. I've only gotten one so far, and I think it's important you get me a proposal so that you don't go down the wrong path with your research project. And note also that they're due by the end of week 7. So just be aware of that and give me that proposal. Make sure you read the syllabus about what the research paper is about so that you can frame your issue or your topic in a way that it can meet those requirements. So that's going to be important to do. Secondly, hopefully this will be a good thing, is looking at week 5. There are 4 learning activities there. And I've decided we're going to eliminate activity number 3, which is where you were going to write up a personal experience of employment discrimination. Because that requires writing another page or 2 of paper, and I think you've got plenty to do, I'm going to delete that from the learning requirements for the 5th week. So you don't need to do learning activity 3. And we'll just do our normal discussion board and reflection paper. Lastly, as I mentioned to you from the beginning, I think at the beginning, this is my first run at doing a completely online course. I've been in the classroom for 15 years. This is a brand new experience for me. You've been pretty patient with me, which I appreciate. Now I guess I'm going to ask for more patience. And also it reminds me, and I try to keep it in mind, that all of you are working full-time, I suspect. And going to school, I admire my students who go to school and also work full-time, because it's a tough road to do. When I did my MBA at Pepperdine about 15, 20 years ago, I remember for 2 years I spent very little time with my family. It seemed like every time I got finished working and I got home, I had something to do with school. And while I enjoyed it, I know it's a lot of pressure, and so I try to be cognizant of that for you. And I'm even more cognizant now because my plea for understanding is quiz 2, which is would normally be on done and recorded by now, I am told. As I said, this is my first time at doing it, and I haven't been able to get that on board yet. Now, what I'm aware of is that normally this would be you'd need to have this done by Sunday. And when I look at my schedule, both work schedule and teaching schedule, I'm going to propose that I'll have that on, say by Thursday, but I'm not going to ask you to take it before the following Wednesday. Seems like it would work. Because that'll give you the weekend to look at the material from this lecture, from the 2 lectures yesterday and today. So if you can bear with me on that, part of this situation is that this is what we call a course build. So this is a new course, although I have taught these topics for a number of years. The reality is that the way we do it at CBU is we put together a template and we put all the materials and so forth into the template. And with time constraints and so forth, I wasn't able to get all the quizzes put together in a fashion that you would just simply click on and find them there as each week went by. So I'm doing them as we go. So we'll probably have a similar situation with quiz 3, although I'm certainly going to do my best to have that one on by excuse me, by Sunday or Monday of the kickoff of week number 8. Excuse me. So that's how we'll handle that. You can eliminate learning activity 3 for week 5, and I will have the quiz on by Thursday. And the research paper, it calls for a proposal. Look at your syllabus on that, and we'll do I'd like you to get those proposals to me. And they're just a page or so. I just want to make sure you don't go down the wrong road with the topic, because the syllabus is pretty specific about what needs to go in there. I'm also cognizant that we're getting, this is coming at me as fast as I guess it's coming at you. I'm used to 14 to 15 week semesters, and these sessions we do here at CBU are 8 weeks. Another thing too, I don't know if you know this, but just to put it out there so you understand, when we build one of these courses, the accreditation agencies require certain components, certain time frames. They require that the various activities, they estimate the amount of time it would take, which is all necessary to certify that your degree is worth something, and it didn't just come along like a mail-in catalog book or something. So that's why the level of activities that are here. And while I don't think they're terribly onerous, I recognize they put some pressure on you. But it's not because we want to inflict pain on you. It's because we're required under the accreditation rules. And that being the case, I think it makes your degree all the more of value and more well respected. And I think you'll get a good sense of accomplishment, as I think you do with all your courses when you get finished and get that degree. I know when I got mine, it was a tremendous thrill, and I think you all will feel the same way when that comes about. Having said that, before I move into intellectual property, I did want to touch on a couple of real-world products liability issues. They're actually cases that I had in my notes last night, but I decided to wait until today to run them by you. The first one I'll talk about involves amusement parks, and involves people who have fallen out of rides at amusement parks and been killed. And I have an article from an LA Times case that was put on. This has to do with a 40-year-old woman who fell out of what was called the perilous plunge at Knott's Berry Farms. And the article goes on to talk about two other deaths that occurred over about a 3-year period. And these were thrill rides in California and New York. And the interesting thing was, or the thing that makes them interesting products liability cases, is that the rides were designed by the same company. The company was called Intamin AG, which makes me think with we use an acronym INC or INC or that sort of thing, and in Germany and Europe they use AG, meaning a corporation. So I have a feeling this is a German company. They're a worldwide company. They make rides that are installed in amusement parks all over the world. They've done roller coasters at Six Flags, and they also have rides at Disney's California Adventure. In any event, I'll just read real quickly part of this. It says, in all 3 thrill ride accidents in parks in California and New York, the victims slipped free from the shoulder harnesses and the lap bars or seat belts. In 2 of the cases, the riders weighed more than 300 pounds. And in one of the cases, or they weighed about 300 pounds, because the woman who's the topic of this case weighed 292, but that's pretty close. And then the third case was a 12-year-old mentally and physically disabled young boy who slipped from the roller coaster and was killed. So here you have a manufacturer who's manufacturing these rides, and you've had 3 people fall out and kill themselves. Get killed. Now, the question that you have to look at is, and one of the responses of the manufacturer was, thousands and thousands, hundreds of thousands of people ride our rides all over the world, and we've only had 3 people, at least in the U.S., so there's no information here on other parts of the world. But what's the percentage? Is it less than 1%? And the question is, do you want to require that a manufacturer be 100% certain that no one will fall out or get killed or injured? And so that's kind of the question that's presented by this products liability case. Now, the case goes directly to the area that I mentioned earlier that is the most significant, at least in my mind, and that's the idea of notice, of warnings, adequate warnings. And I'll touch on that in a minute, but let me, this is the story of a woman named um, Lori Mason. Lori Mason. She was 40 years old. She rode a ride called the Perilous Plunge at Knott's Berry Farm. It's billed as the steepest and highest water ride, where it drops 115 feet and the ride hits speeds of 50 miles an hour. The ride is equipped with seat belts, with a T-bar that pulls down over your lap, and with what they refer to as a grip bar, which is the third restraint, which is what you hold on to in front of you. I'm sure many of you are familiar with this sort of thing. And in any event, she was thrown out and killed. She weighed 292 pounds. She was 56 inches in girth, they said. And the coroner's report and one of the experts on the ride said that it would have been very difficult, if not impossible, for the lap bar and the seat belt to work on someone her size, which to me infers that either the lap bar you pull down, and I think we've all felt them click in place, didn't click in place or wouldn't, and also that the seat belt may not have gone around her. And so the question then is whether there was liability on the ride operator, and therefore Knott's Berry Farm. Because if you know, you go to various rides, I know in Disneyland, for example, and those workers running the ride will walk along and look at every single seat, and it's presumably looking to see that belts are tight and clicked, closed, and that the T-bar is down over your legs and thighs. We don't know about that in this setting, but in any event, the presumption is that, or I think you could presume that she either rode without them connected or they failed. And the case has just been filed, so we don't know what the outcome would be. Now, here's some of the problems, though, that the manufacturer has. It says they had no warnings anywhere on the equipment that said that you had to have a weight limit. And the operator indicated that we operated this ride based specifically on the instructions that were given to us when we bought the ride. Knott's Berry Farm said the Perilous Plunge does not have any posted weight restrictions. A general warning in the manufacturer's manual that only people who can be safely restrained should get on the ride. Now that you're looking at the issue then of adequate warnings. Are those adequate warnings for the riders, for the consumer? This is who we're protecting as a consumer. I think you can find fault here both with the operator and probably with the designer. But then again, is that responsibility of a weight limit? Should that be imposed on the operator because they're the ones there seeing the person getting into the ride and determining whether they think they're too large to get in there? Now, another damning thing that the CEO of Intamin said, she said, Intamin's rides are designed for a person weighing an average of 175 pounds, as are most amusement park attractions. Now, to me, that's pretty much put her company in the box, regardless of how you feel about these issues of responsibility for someone who's overweight. Because what are you doing designing this thing for someone 175 pounds? It's very evident to me that not most, but many, many Americans weigh over 175 pounds. And so I think they got themselves in a lot of trouble with that statement because it's really for them more warnings on the equipment. So maybe they should be putting, the question is, where do you put it? Where do you put a sign that's noticeable? Not only that, you've got to train or instruct the operators, the people at Knott's Berry or Disney, whatever, that anyone that appears to weigh over a certain amount of poundage, then that you have to prohibit him from getting on the ride. Now, of course, if you've taken young children, as we have taken our grandkids to Disneyland, they have height limitations. And you'll see we have a little grandson who's just 3, and his sisters who are older, they meet the height requirement of 48 inches or whatever it was, and the little guy is much shorter than that. And of course, his heart gets broken because he doesn't get on the ride. But nonetheless, they actually have the board. I'm sure you've probably seen them with the inches running up one side, and the child goes over and backs up against the board, and you put your hand over the top of their head and see where it comes out. And if you're over, so now what, as a society, as a culture, are we going to say that these operators have to have a scale? I mean, do they have to have a scale that says, you get on the scale first? Well, you know how a lot of people are very, very shy and embarrassed about their weight. And there's lots of reasons for people being overweight and whatnot, from eating to psychological issues and so forth, as we've all read about. So, if you have those issues, you have those issues. It's a personal matter you're dealing with, and so do you require them to put a scale that you have to step on, and then the operator has to say, well, you look overweight to me, and you look okay, and you run into those practical considerations. And I imagine you'd hear those kinds of arguments in the courtroom by the lawyers defending the manufacturer. But in any event, it's uncertain as to where these cases are going to go. There's 3 of them, and they're all pending now in the U.S. I think in my mind, there are some questions about whether the manufacturer could have done more in terms of warnings, maybe put them in a more prevalent place. Certainly in my contract with the operator, with Disneyland or whoever, I would attempt to have an in-depth contract that said that you're responsible for observing those people getting on the ride. We've done the training, and now this training manual's on to you, and we believe the rides are safe, and therefore the obligation, the responsibility is yours, and try to transfer that. So as a manager, you're trying to do that. If you're the VP of sales for Intamin, then you're talking to your legal department saying we need to put something in there like that. Those are adequate warnings, at least to the operator, and that might give us some defense. It makes logical sense that the manufacturing company's not going to be on the scene, but see, that's the whole idea of strict product liability. Is the manufacturers may not going to be at Home Depot when I come in to buy my chainsaw. So, how far do you go in terms of allocating that responsibility? Now, on the other hand, the problem that the manufacturer has here is the testing only went to 175 pounds, or that's, I think, that's what she stated, that we tend to test them to that weight. And that, to me, creates some vulnerability for them. Under this concept of foreseeability. I mean, I think clearly the argument would be made by plaintiff's lawyer that to the jury that you clearly could foresee that there are a lot of people over 175 pounds and there are a lot of people over 200 pounds that are going to want to go on this ride. And so you need to do more. We want the manufacturer to do more than test. So this would be a design defect. I'm sorry, this would be a manufacturer's defect in terms of testing. So you can see the concepts of foreseeability coming into play, the adequate warnings or inadequate warnings, and it's somewhat subjective on each case, each product, whatever it might be. How much warning should you give, and how do you deliver that warning to deliver it effectively? And then how much are we going to hold you to foreseeing the kinds of product misuse or the injuries that could occur because of some use or of the product that wasn't what you foresaw as being a usage of the product. The same token with respect to this manufacturer of the rides, with the customer, the consumer, this person had to know that they were pretty overweight. And of course they wanted to get on the ride, but by the same token, do they have some responsibility to be careful? And I would think that to a large measure, people want to just live their lives without having to constantly think about that. And so maybe this woman just felt, well, I want to get on the ride, and I'm not going to say, well, am I too heavy to get on this ride? I mean, she wants to get on. There's people all around. Those kinds of things happen. So to me, if I were counsel, if you're the manager of AT Intamin, I am saying that number one, we have to go back and test test up to 250. I'd test up to 250 pounds, which I think would give you a good threshold to make your case that anyone over that really has no business. But then I would try to transfer that liability to the operator with a manual with significant notices to them, having them sign off on the contract, which makes them accept, acknowledge responsibility for supervising those getting on the ride. In other words, my product has to be safe, and I have to have tested it in the best way I could to make it safe. But in terms of where the determination's made about whether someone uses it or not, that needs to be made, I think, on the scene. And in that setting, I would try to transfer that liability to the operator. And you have the obligation or duty to either, I don't care if you weigh them or whatever you do. Now, of course, the operator's not going to go that far to weigh people, but certainly they need to be instructed to tell them about a weight limit, and that and then you try to transfer responsibility. If you're the attorney or the manager, you're in management for Disney, then you're looking at it from the standpoint of, well, I want to transfer some responsibility further down the line. So I want to put some responsibility on the person using the ride to consider the fact that they may be overweight, they may be too heavy. And maybe you put little plaques right in front of each seat that says, if you are over 250 pounds, you should not ride this ride, or something to that effect. Of course, it might be a little, park operators might think that's unsightly and so forth. And to another from another dynamic of this thing, another aspect is, the park may think, well, that's aesthetically not very attractive. You've got these little stickers or labels on right where the person sits down and says, if you're over 250, get off. But it's an attempt to transfer the liability a little bit and move it over to somebody else, or reduce, remember, comparative negligence, to reduce your potential exposure, because you're talking about money. What's your exposure? Likewise with the testing, you're talking about how much is it going to cost. Remember now, as a business person, every new regulation, every new step you take in the process of building your product is going to cost more money. And so testing is going to cost more money. And then it's going to cost more money if you have to reconfigure your seat belts or your lap belts. So you can see all these decisions from a business standpoint go back to the cost, and then it has to do how much can you sell the machine or the equipment for. If you have to add another $2,000 in cost to the device, then do you have to increase the price by $3,000 or $4,000? And then if it goes up, and now the ride that cost, let's pick a number, the ride that costs $250,000 now it costs $325,000. Well, maybe the park's going to go buy it from somebody else. So you have all these factors coming into play, and these are all legal issues that management would have to look at and consider, and then make as best a business decision with the collateral considerations of the law to see what the risk is. And you do, I mean, not sadly, but in hard-nosed business decision making, you may say, we can afford to raise this to 200 pounds. We'd like to do it to 250, but 200 is the most we can do. And it'll be at a cost. Or you can say, you know what, this ride is ridden by millions of people every year. Like the article here, it's been ridden thousands, hundreds of thousands, tens of thousands of people, and 3 fell out over 4 years. We're going to take the risk. We're going to, if they fall out, we're going to try to settle with them. Doesn't sound great, but the other side is, can you make a product 100% safe? Of course, that's the goal. But are we going to hold a manufacturer responsible under strict product liability for anybody that gets injured in any way because they're around or near the equipment? So that's a big issue. Now I want to move quickly because I see I'm already into more time than I had planned on, and I apologize for that. But as you know, I can get a little long-winded on this stuff. Hopefully not too repetitious. But here's another one I'll try to do quickly, which it raises some interesting issue. And this says trial opens in suit against paintball gun maker and Walmart. And what you have here is you have three young teenage boys, 15, 16, and they went to Walmart and they bought a paintball gun. Now, if you've ever known about paintball, and I've had the thrill of playing paintball a few times, and it really is pretty thrilling. The equipment's gotten a lot different now. When I played it, they didn't have all these automatic paintball guns. If you've ever seen any of the shows on them where they fire paintballs at 30 rounds a second or whatever it might be. We used to be able to fire them once or twice in the course of a few seconds. But in any event, it's an exciting kind of thing to sport. But you wear goggles, ski goggles, and you can wear different types of light vests if you want to. The paintballs are made to break as soon as they hit you, and while they're not supposed to be terribly harmful, they can cause, if they hit you the right way, they can cause a whelp. A red raised whelp on your arm or neck or wherever where you happen to get hit by the paintball. Well, these boys went and bought a paintball gun, and then just for a lark and the fun of it, they went out riding around in their car shooting the paintball gun at other cars, and as it turned out, probably other people. And as you would suspect, a lot of teenagers congregate around various places, and in this setting, there were a bunch of kids congregated around a Swenson's ice cream parlor, and I'm not sure what state this occurred in, but they were around the ice cream parlor, and these three young boys, the shooter, if you will, was a kid named Justin Barton, who was only 15, and they're riding around, and I'm sure they cruised by the Swensons where they probably knew these kids were high school classmates or whatever, and they fired off the paintball gun. I would probably think it was funny too when I was 15. It's just a little thrill, a little kick, and everybody talked about it in school the next day that Joe Blow came by and fired. We got paintball all over ourselves, and paintball pellets, by the way, wash off, so that the paint's not permanent. But in any event, sadly enough, they hit this little girl in the eye with a paintball, and her name was Jarrell Travis, and she was 18. And she was blinded in her left eye. Now, there were criminal charges brought against James Barton, and he paid restitution, and the judge, I think, in order to make a point, sent him to jail for 6 days. So he was in jail for 6 days. I would think that would get his attention. Not likely he's going to do that again. And the other two boys were not charged. They were just in the car. One was driving. But now here's the situation. I'm sure there was probably, believe it or not, sometimes homeowners insurance will cover this kinds of thing. Or sometimes there is no insurance, but the family has money or whatever, and they settle. So what happened here is that the Barton family settled with Jarrell Travis's family, and it doesn't tell you how much. But the big money in this case would be against Walmart and against the gun maker, a company called Brass Eagle, who made the paintball gun. And so here you have your classic products liability case, strict products liability case. Remember though, you can do your suit on the three bases. You can do it on negligence, you can do it on misrepresentation, which deals with the advertising, and you can then do it on strict product liability, which is a lesser burden of proof. So in any event, they have gone against both of them. Brass Eagle Manufacturing sold the gun to Walmart, who sold it to these young kids, and the lawyer says they did this, and the evidence shows that they knew more people would be hurt, including people like Jarrell Travis, the bystander not using the gun. There were warnings on the packaging and on the gun, but Barton never saw them. Okay, this is according to the plaintiff's attorney. So Barton must have given a deposition and said, well, I never saw any warning labels. So that certainly helps the plaintiff's case, because now right away you're going to say those warnings were inadequate because the consumer didn't see them. Well, I'm a lawyer, and when I went in to refinance my house and I had 25 documents. Did I read them all? Heck no, I signed it, and I'm embarrassed to say that, but we all do that kind of thing. You buy a car, you sign the papers. Sign the papers. I want the keys. I want to get out on the road and drive. So in this setting, they had a paintball gun in a box. They open up the box, get it out, load it, and start shooting it. They don't read anything. So this is kind of the part that has me going both ways in terms of right and wrong or legal liability, because they put warnings on the box apparently. Now what they were, the article doesn't tell us. How prominent they were, the article doesn't tell us. But the bottom line is they did have some warnings. And I'll read a little more. It says, Brass Eagle prints warnings on its boxes and in instruction manuals that the gun is to be used only when people are wearing the proper safety masks. And actually the more serious paintball people in today's world wear a full mask. It's almost like a goaltender's mask, if you've seen those, that covers the whole face, and you can look out. But even with that, with all the people playing paintball, what's the probability of an unlucky shot that goes right through the hole in the mask where the eye is? So, I mean, there's no 100% safety with this kind of situation. And so you're to use the proper masks, which are sold either with or next to the paintball guns. So they're right there. The attorney for Brass Eagle says paintball is safe if it is played by the rules. He says even in baseball, if misused, someone can get hurt with a ball, getting hit with a ball, and so forth. Brass Eagle's attorney and the paintball maker, another name for the gun, functioned properly, but was not used in a proper manner. So now you've got the product misuse. Is this a product misuse? You don't have a knowledgeable user necessarily. Commonly known dangers, maybe you could possibly make those arguments. But then turn around and the plaintiff's lawyer is going to say, you should have done more, put more warnings on the gun and one thing or another. But you're back to this whole idea, even like with the roller coaster cases. Who's going to monitor this? I mean, who's someone going to ride along with these kids every time they take the paintball gun out, or the parents have an obligation to say you can't use that paintball gun? Well, maybe they've all got masks and everything, and the parents don't know they're going to go out in the car and ride around and shoot the paintball gun at people. Is that really foreseeable? Well, maybe it is for teenage boys, but again, how strictly can you apply this law, or what degree of care do you want to impose on whoever, be it parents or the kids or whoever, for this kind of thing? And I don't know. I was thinking about this morning before I started talking about getting ready to do this lecture, which here we go again, right, time-wise, sorry. And I thought to myself, at what point in time is something an accident anymore? It seems that there is no such thing as an accident anymore, that somebody's got to be responsible for it. And it's like my kid diving in the water in the ocean and fracturing his spinal column. I mean, it's tragic, but it was an accident. No, it wasn't. When the court got finished, it was responsibility of Newport Beach. So again, I kind of wonder about where some of this stuff leads you. So anyway, that's your paintball gun story, and two products, strict liability. Remember, we're trying to protect the consumer. There's no privity of contract. That's the idea where the manufacturer that sold the paintball gun to Walmart, they were not in the transaction between the boy that bought it and Walmart, yet they're still brought into the case as a potential defendant. And the idea here is that it's strict product liability, and that they really can't get them on negligence and false advertising. Because what a paintball gun does, it shoots. So what kind of advertising are you going to, what kind of misleading advertising are you going to put in there? Negligence, I don't know. What's the duty of care they owe? Because once the gun is delivered to the user, what possible way do they have of monitoring, managing, supervising the use of the gun? So the only way to get the manufacturer in this case, and Walmart for that matter, is products liability, strict products liability. And that's the concept we've talked about. Much too long now, I will admit, but that is. So, but you can see the management issues there in any product you put out. What's the foreseeable risk of someone getting injured? Is it an ultra-hazardous product? What safeguards have we put in there in design and testing? And then lastly, the big one, as I said, is inadequate warnings. When are the warnings adequate? And that's usually almost always a jury question. There is no law, no, we call it black letter law, that says this is an adequate warning, this is not an adequate warning. And the reason, of course, is because the products are so diverse, they do so many different things, and operate in so many different areas of human activities, that it's hard to know what an adequate warning is. So now you're back to a jury using common sense. And you can only hope that they'll apply common sense to a determination on something like this. Okay, let me have a sip of water here, and I will try to move this along now. And I say that every time, so I apologize. I like to talk, I guess. So, okay, again, it's a nice and bright sunny day out here. A little break from the listening to me drone on about the law. Okay, now we're going to talk about intellectual property, and I said at last night when I talked to you about products liability that this topic also is equally important, but maybe important from a different perspective. Whereas strict products liability deals with management issues, decisions of liability, of exposure to lawsuits and so forth, for injuries and so forth, intellectual property creates issues for management to think about in terms of protecting something that you have invented, something that you have written or designed, your customer lists, proprietary information about how you do business, about your product and so forth, and how the product is made and whatnot. So this is also an extremely important area, and in today's world even more important, particularly with technology, but with other types of inventions as well. It can be equally important. So here are the four major areas, and you might want to just jot the four of them down on a piece of paper. I'm going to go through in more detail, but the main topics are, the main areas of intellectual property are trademarks, like Coca-Cola, like the Mercedes, looks like a peace symbol, I guess, the round Mercedes symbol, like the swoosh on Nike shoes. Those are trademark type things. Then comes patents, and patents, as you know, are on inventions, so they would be the ones I talked about last night about medical devices and whatnot, and I have a story, personal story about that for you when we get there. So those are patents. Then you have copyrights, and copyrights are creations of the mind, and they are things such as writing novels, writing textbooks, choreographing dance, doing movies, the scripts, writing the screenplays, and then actually making the movie. Those are all under the copyright area. And then last but not least is what we call trade secrets. And trade secrets are those things that a business has developed for itself that gives it, that item, whatever it might be it a customer list or a price list or whatever, has economic value to the owner, and if taken out into the public would cause the owner to lose some competitive advantage they might have. And so, and the classic cases are employees stealing customer lists, or employees even taking equipment, or some engineer who sees the way the device is made, goes out to make a device somewhat similar and tries to get away with that. So those are trade secrets. Well, the device is a bad example because that's really more a patent issue. So in any event, this is what you're doing in intellectual property, as opposed to making decisions to avoid liability for damages and injuries. Here, you're making decisions to protect your device or your work of fiction or novel or your movie, or the big one, of course, is recordings, is videos and CDs of music and whatnot, which sadly are pirated all over the world, China being the worst offender of that kind of thing, because it costs it costs the music people billions of dollars a year. When and you all may or may not remember Napster, which was the owner of that, it was a young fellow, called it file sharing, but basically what it was downloading copyrighted music among hundreds of thousands of youngsters in the country. And it was costing, and it was illegal. I mean, it was a violation of the copyright laws. These people spent the money and the time to produce and make these CDs and whatnot, and the songwriters and the performers, who all get a piece of the action. they do these to entertain you, but to make a few bucks every time you buy the CD. So anyway, so those are the big areas: the trademark, patents, copyrights, and trade secrets. So let's talk about trademarks real quick. They're a distinctive mark, or could be a motto. For example, BMW uses the ultimate driving machine. You'll see Pepsi and Coke come up with different jingles and short sayings for their product that become trademarked. And the concept is to prevent confusion among the consuming public, so that if you go to buy something and it has an emblem on it that says it's this product, it turns out it's a knockoff or some other product, then you've been confused and you spent your money for something and you didn't get what you thought you'd get. So the whole idea with trademarks is they belong to the person who put together the trademark and designed it and so forth, or the jingle or the motto, and no one else is to use it. And so that is a trademark. And the first major statute, and there's only two, and I would like you to know what they stand for, and it's not complicated, it's not complex. The first one's called the Lanham Act of 1946. It was passed, as you know, after World War II, we had become an industrial power. This one focused more on products, on tangible products, because we didn't have the technology and what I call the soft or intangible products we have now with software and whatnot, but it was primarily with tangible products. And the whole idea is that you could not, if you trademarked or patented something, you could not, someone else could not copy that and make it a competing product. So that was the Lanham Act of 1946. And then, and the way it was set up though is that it was confined to the same industry. So there's a case in the book here, I think the Coke case, where someone else, another company, was trying to sell a product that they called Coke, K-O-K-E, I think it was, versus C-O-K-E, and that was a competing product in the same industry. So it had to be in the same industry. There wasn't a lot of using a product in a different industry, because they really didn't interchange or substitute very well. But at that point, it was primarily tangible products. Now the next statute was the Federal Trademark Dilution Act of 1995. So you got the Lanham Act of 1946, which was the first statute that prohibited you using the copying the patents and the trademarks of another business in the same industry. You'll note that the second statute in 1995, called the Federal Trademark Dilution Act, and the word dilution is the key, because in 1995 we recognized, the government, the makers of the law, Congress recognized, that people could try to use a name in one industry in another industry. This is a lame example, but everybody's heard of McDonald's. And so, and that gives off, the whole perception of McDonald's is you go to a McDonald's in North Dakota and a McDonald's in Arizona and a McDonald's in Florida, and they're all the same. That's the idea of branding. And branding became very, very important, very expensive to do, and very valuable once done to a product. And so what the Congress was saying is that if you try to use that brand in some fashion, that with the idea being to create that perception, then you've infringed on the trademark. And my example, which is poor, is using the Mc whatever. So you could have McDonald's or McShoes, but you see, you're stealing off that McDonald's thing, because they have the Big Mac and they have, they use the Mec whatever in a lot of their products. And here, if you try to use the term McShoes, the idea being, well, you've got great shoe stores all over, and maybe even you have some relationship to McDonald's. I mean, that McDonald thing has become a trademark and as viewed as creating a certain perception. So there's another case on page 310 if you're interested, and this one makes out a pretty clear issue. And you have a coffee shop named Sam Bucks, and Starbucks sued to claim that they were infringing on their trademark. I haven't read the case in a while, I admit, so I think it's a coffee case, but I'm not certain. Even if it is, it's probably not in this setting because it's probably some other industry. But the idea of Starbucks and Sambucks and are they, are they too closely associated that you're trying to gain some economic advantage from the use of a name that's similar to Starbucks. That's what that part's all about. Okay, trademark registration is done at the U.S. Patent and Trademark Office. So your trademark registration, you'll see the TM registered on a product, a little circle down the bottom of the product somewhere. And so what they've done is registered the trademark with the U.S. Patent and Trademark Office in Washington, D.C. Uh, you must register the trademark within 6 months of your intending to use it, or you have to use it within 6 months when you register it. You can't register it and just tie it up. So you have to use it within 6 months of the date that you registered, or it's open to someone else to use. The book tells us you can get an extension of 30 months if you file the registration, and then there's another extension of 5 to 6 years. Don't be concerned with that. Just know it has to be registered, and you have to use it within 6 months of the date of registration. And if you can recall, you can get it extended for 30 more months. That's fine, but what I really want you to know is the registration process, and it's got to go into use within 6 months. Trademark infringement. Now this is the name of the action, the legal action against someone who's using your trademark, and it's called an infringement, and in this case trademark infringement. And the way it works is it's national protection. So once you register that trademark in the entire United States, that trademark is yours, and anyone who tries to use it or is using it is infringing on your trademark. Now this usage of the trademark, it can be intentional or unintentional. So the other party can intentionally be using it, in which case clearly they're infringing on purpose, or unintentionally, and they're infringing unintentionally, not meaning to steal the use of that trademark. The remedy is, and you can see why, is an injunction. And the reason is, if you file a lawsuit, as you've heard me carry on in chapter 3, if you file a lawsuit, it could take you anywhere from 2 to 3 years. In the meantime, the person's using your trademark and making a fortune. So the proper remedy for all these intellectual property cases and infringements has to do with a remedy of injunction, where the court issues an order and says, as of today, you will stop using that trademark. And if you don't, you're going to be in contempt of court and maybe find yourself with some criminal type sanctions possible. But the whole idea is that you have to stop immediately. Now, there are damages, though, because if you can demonstrate actual dollar losses, you can sue for those losses, and you can sue for anticipated profits. So let's suppose someone infringed on your trademark, and you can demonstrate they sold 100,000 items using your trademark. If you look at what the profit margin is there on that product, you're entitled, you can sue for damages and asking to have the anticipated profits that you were going to get. Probably most classically would be in a CD, where someone used the trademark on a CD, packaged it in a little plastic holder, and it looked like it was coming from this major company, for example, and it turned out it was somebody with a little garage operation going, and they'd just basically taken over your trademark. So you can sue for your damages there, and in some cases the court can order the product be destroyed, and they've done that, where they found these rings that do the counterfeit CDs, and they'll gather them all up, and a lot of times they'll hit a warehouse and there's thousands of them in there, and they'll pull them out and destroy them all. There's a thing called generic terms, and generic terms are terms that at one time were the name of a product or viewed as the product name, and then became so commonplace that they became generic. And the two most well-known ones probably are the term Kleenex. The company that invented a Kleenex was the Kleenex company, and they called it Kleenex. And now we all say, do you have a Kleenex? That is now viewed as a generic term, and there's no infringement there. So Kleenex can't sue everybody or anybody else that makes tissue, because a lot of people make tissue, because Kleenex, because of common usage over a long period of time, it was viewed as a generic term. Another one is thermos. a thermos bottle to put hot coffee and whatnot. The company that invented that and started it was called the Thermos Company. And that term thermos has become a generic word. Aspirin, I think the first company that did aspirin was called Aspirin, and that, everybody, no matter what product you're taking, Advil, one thing or another, very often you'll just say, I need to take an aspirin or whatever. In fact, and now that I think about it, when I talk about this branding, and I think about it, now people actually do say, I'll take an Excedrin, I'll take an Advil, I'll take a Tylenol, as opposed to taking an aspirin, whereas aspirin was the product that was probably predominantly used in the country back in the 20s and 30s and maybe up to more recent times. Now everybody kind of basically says, I like Tylenol, I like Advil, I like etc. What's that an example of is the branding. That's an example of branding. They've branded those names that people know that that's the kind of pain reliever they want rather than an aspirin. And so those names are protected. And they're protected under the Trademark Pollution Act of 1995. So those are generic terms. Let's talk about cyber marks. That's a new one. It's kind of a subheading of trademarks. It deals with domain names, okay? And the domain name is the name that is used on the left side of the period before you get to .com. So whatever that name is on the left side of that period is the domain name, and those are protected under the cyber squatting. They call it the Anti-Cyber Squatting Consumer Protection Act. So long, you can just call it the Anti-Cyber Squatting Act if I ask you to mention what it is. But basically, the idea here is to protect these domain names from others trying to appropriate them. Now, what's happened to clarify things more, give more certainty, is there's an outfit called ICANN. It's all in caps, and it's ICANN. You'll see it in your text, ICANN. The long title of this, an acronym, is Internet Corporation for the Assignment of Names and Numbers. But basically, it's where you register domain names, and they oversee all of them being registered. So now, in fact, I think you can go online now and stick in a name, and it'll tell you whether it's in use or not. So the whole idea is to protect those domain names, which are viewed as cyber marks, from others using them when you're using them for your business. Cyber squatting, an example of cyber squatting, there are companies out there who buy and sell domain names. And one of the most early famous cases and goes way back, because you'll know that the Raiders came into LA and left and have been gone quite a while. But when they first announced they were coming to Los Angeles, a couple of wise guys went out and reserved the domain names of LA Raiders, Raiders.com, Raiders.net, any word they could put together with the Los Angeles Raiders, they registered. And that's called cyber squatting. And because people go out and try to anticipate a domain name of a big product, and they go out and try to register it. It's not as much done as it was because of this law. But in that setting, these fellows, out of the kindness of their heart, offered Al Davis to sell them back their domain names for $200,000. And as I read about Al Davis's, God rest his soul, some of his background, there was always some suspicions that he was involved with the mob, and or had some mob contacts, and I don't know if that's true, so I'm spreading a vicious rumor. But he's a public figure, so I can't get sued for defamation. But in any event, I think I would have been wiser to just give them back to him. Instead of asking $200,000, I'd be finding out in the L.A. River somewhere, floating or not floating, in a concrete kimono. But in any event, they tried to register that name and then sell it back to the obvious user. It'd be like trying to get Coke.com and then tell Coke you'll sell that name back to them. Not going to happen. The courts are not going to allow that. It's called cyber squatting. Now here's an interesting one, a new concept called typo squatting. And that's kind of an interesting area in a way, typo squatting. What that is with the search engines, you're going to put the name in and the domain name or a name similar and hope it comes up and you can find it. And you'll get, as you know, lots of somewhat similar, but generally they're not the one you're looking for. Well, typo squatting has to do with purposefully misspelling the domain name, a registered domain name, with the idea that the search engine's still going to grab it because it's so close to the domain name that most people would be going for with respect to that product or that device or that service. And so that's called typo squatting, and that is also comes under the anti-cyber squatting law, because clearly what you're doing is trying to take advantage, reducing the economic value of that trademark, in this case a cyber mark, a domain name, and you're using that misspelling on purpose, which is, and you can determine whether it's, of course, most of us would know that's a misspelling on purpose because you want the search engine to pick it up. So that's typo squatting. Meta tags, META, and then tags, TAGS, and meta tags are websites' keywords. Again, keywords that the search engine would pick up, and very often that is viewed as a trademark infringement, where people try to put a word in, keywords in that are similar to someone else's website's keywords, and the court will say that you're infringing on their meta tag. Now, the best way to deal with, and you'll find this in most, certainly in trademarks, you can find it in patenting, but mostly trademarks and copyright, because software is copyrighted. The way to solve these problems usually is licensing, because patent work is, or intellectual property work, particularly in court, is an extremely long process. And so rather than get involved in a huge lawsuit over patent infringement or copyright infringement or trademark infringement, a lot of times the parties will license not so much the trademark, but they might license the patent or the copyright on a product. And we'll come back to that and talk about that in a minute. But licensing is usually the way to resolve a patent infringement case or a trademark infringement case, and is normally the way it's done. And you can put restrictions on licensing, and if you take a quick look at 315, there's a case on Perry Ellis, as you know, is the clothing manufacturer. Let me find this real quick. And I'm going to get my pages over here. Perry Ellis is on page 315. Take a look at that. Perry Ellis made footwear, and they entered into a licensing agreement with a company in Mexico, and they had restrictions on the licensing. It's just a short little case, about 12 lines long. You might want to glance at it. And what happened was Perry Ellis sued them for violating the licensing agreement. So the suit now wasn't an infringement suit; it was a violation of the licensing, which is a contract suit. But the point is, if you want to license your name, in this case they licensed Perry Ellis, the name Perry Ellis, the Mexican company started using it for other things or in ways that were contrary to what the license said, and Perry Ellis sued him for it, and I think won. Okay, patents. How are we doing time-wise? Patents. These are granted to the inventor of a product or a device, granting him the exclusive use to make it and sell it. Okay, so that's the idea. The inventor gets granted the exclusive use by virtue of a patent to make and sell his product or his invention. And generally that product, or sometimes we call it a process patent, is a 20-year patent. So that device will be patented for 20 years and no one else can build it or make it. And what happens in business, can happen, and some often does, is people will go and reverse engineer the product and then build their own and under a different name because they can see how it was put together. There was a company here in AST Research here in Irvine, and they actually did that with the first IBM laptop computers. And then they reverse engineered them. It was three smart young fellows with engineering backgrounds, and then they modified theirs enough that they withstood IBM's claim of patent infringement, and they were able to build the AST computer and sell it. And at one time they were the third or fourth largest manufacturer of hardware desktop computers in the country. So that's a 20-year patent. Now, a design patent is a different kind of patent, and that will get you 14 years of coverage, okay, in a design patent. And that has to do more with the design of the product and so forth versus the process that the product completes. Also, let me point out, the first to file a patent isn't always the one who owns it. So if you can prove that you made the same device and had it out and sold it, or had it out in the marketplace before the person who registered it, very often you can be deemed to be the owner of the patent. Once the patent expires, you're free to sell it. Now, drug companies get patents on their medicines, on their drugs. And you all know of generic drugs, I imagine. And what happens is when that patent expires, and for the drugs it's 14 years, then the generic drug companies go out and make it, because they all know what the compound is. They can reverse engineering and know what the compound is. You don't get much infringement of drugs in the country, and in the world for that matter. It's pretty strictly controlled, and people tend to adhere to it because it's not hard to prove that you just get a couple of their pills and you can tell they're the same. So the drug companies usually get their money back. Their claim is we have, we spend millions on research and so forth, and billions, whatever. Therefore, we should get the margins we get. And if you've ever had someone send you some emails about drugs and so forth, and you'll see that the cost to make a pill is $150. I'm sorry, is $1.50, and they're charging you $75 for per pill, or that sort of thing. And it gives the drug companies a bad name and a black eye and whatnot. But the fact remains that they, to bring a drug to market takes anywhere from 5 to 10 years. And so the idea with their getting a patent is that they're entitled to exclusive use to recoup their money and make a profit. So that's the idea of patents and process patents and design patents. Now, the patent itself, first of all, it's a very specialized legal area. And I'm sure many of you have heard of patent lawyers. And patent lawyers are very often, they tend to have technical backgrounds. And in many, many cases, they tend to be engineers. Because many times what they're being given to patent, they need to be able to look at it and get some sense of its workings and what's involved in it and so forth. So patent attorneys often have that kind of an engineering background, so they can check it out. And now, when you file a patent application, you file claims. They're called claims. And what you do is you take the drawings of the patent, the drawings of the device rather, and you try to identify as many unique aspects of the device as you can. And it can be from its materials, to the thickness of the materials, to the way the materials put together, to the parts and pieces and how they all operate in one thing or another. And you try to create as many claims as you can. Your claims are claims of uniqueness. That goes to the patent office with your application and all your drawings and design work. And the patent office then, with their experts and the people that have a lot of knowledge in that area, look at it and decide whether they think all these claims are in fact unique. And very often what will happen is you file 48 claims that you say are unique, and the patent office comes back and says, we'll grant you 30, or we'll grant you 8 or 10, or whatever it might be. Because they think that some of your other claims are already out there, or they're common knowledge, or they're kind of viewed as somewhat as a generic piece of the device or what have you. So a lot of times the claims that are granted are less than the claims that are made, and it's very common because you're trying to cover as much as you can. And I'll tell you my quick story. I was involved with a company. We had a little startup company with a medical device. Our company was called Cardiovascular Innovations, and we had a blood pump oxygenator that was used for bypass surgery, because when you do open heart surgery, you stop the heart, and they have these heart bypass machines which are about as big as a credenza. They're stainless steel in the operating room. They're big, huge machines, 10 feet long or 8 feet long. And our blood pump oxygenator was the size of a blender. In fact, it looked like a blender, and it did the same thing. And we had venture capital money involved with us. We were raising money, we were doing clinical trials and so forth on this device. And we originally filed, the patent was filed with I think about 32 or 33 claims and came back with 26 or 27 claims. So we had 26 unique aspects of it. So that if anybody used any of those 26, then that's patent infringement. And what was really unique about our blood pump was the way it spun the blood. Because one of the problems with the blood, when you're oxygenating the blood, you have to spin it to get the CO2 out and reoxygenate the blood. And there's a thing called hemolysis, and if you spin it the wrong way, you fracture the red blood cells, and the blood is no good. The blood cells are no good, so the blood's no good. And our device did not fracture them; it worked. And the outcome of our device was a sad story, so I won't bore you with it, except to say that we lost our funding, and had to abandon it after about almost 4 years. And I think of all the things I've done in my law life and business life, this was one that was a huge disappointment, because this device was really going to save lives in my mind. And where I thought it would work the best is because of its size. We could put it on the EMT trucks, the ambulances and whatnot, and the EMTs could carry it with them. And it was so small you could hook a heart attack victim up right there as soon as you got to the house, or if they were on the street, you pick them up and you hook them up, and it'll pump their blood and everything, so the brain doesn't die while you're getting to the hospital. As you know, heart attack victims, if you can get them to the hospital within 30 to 45 minutes, their survival chances are enormously larger than if it takes you an hour or more to get them there. Mostly because a heart attack, the blood is coming out of the brain, and you get brain damage, and then you get almost like stroke type issues, I guess. So, but in any event, we lost our funding on it, and it was a real disappointment for me. Okay, patent infringement. If you infringe on a patent, it's a tort, which is viewed as a lawsuit for damages and injury. I realize I hadn't talked about torts yet, so it's just a French word for an injury that's causing damage to someone. But you can sue again for infringement, for damages, for lost profit, and all that sort of thing. And of course, your immediate remedy is injunction. You can file for an injunction immediately. How are we doing time-wise here? Okay, we're going to get in under an hour and a half, I promise you. Copyrights is the next thing. So we had trademarks, we have patents, we have copyrights. And copyrights, as I said, remember, they are creations of the mind. They tend to be literary works, so they'd be books, novels, movies, music, choreographed dances, plays, I might have said already. And computer software has been viewed as now being something that can be copyrighted. Now, what's the time of protection? Now, with the patents, it's 20 years and 14 years. Okay, design patent 14, a process patent or a product patent 20. Here, there's two aspects of it. One is the author, and the other is the publishing house, if a publishing house is publishing something. So with the author, the protection period of the copyright is the life of the author. That is, how long the author lives. When he dies, you add 70 years. Well, that's a long time. But believe it or not, there are some old standby stories. The Night Before Christmas might be an example. Or what's the Scrooge and whatever, I forget, that was written in the 1850s or 1860s. That's lost its copyright now, because the owner's been dead a long time and 70 years have gone by. So for a literary work, it's the life of the author plus 70 years. For a publishing house, it's 95 years from the date of the publication. So the date it's published, it's 95 years before it goes off copyright. Now, the other thing is, you should notice, you can't copyright an idea. And you say, well, what's an idea? The best way to explain it is, it would be a theme that becomes almost like a generic theme. So what's an example? A Cinderella story. Okay, the young girl who is working at McDonald's and meets Warren Buffett's son, and they fall in love. Those kinds of stories. A disadvantaged woman, or you can have the reverse in today's world, right, ladies? You can have the guy who's disadvantaged and meets the very wealthy woman, or whatever, and is rescued from a life of drab, common existence like me or others live, into the jet-setting yachts and going to Monte Carlo kind of lifestyle. And it's the Cinderella story. And you've seen movies 100 times that have that same theme running through them. And so you can't copyright that that theme and say no one else can use that theme in a play or a movie or a book. Another one, you may or may not know this name, but there was a movie that came out called, it's a rags to riches concept. Horatio Alger was people would say, if you tell them the story, well, that's a Horatio Alger story, where it's someone who was terribly disadvantaged and through their own efforts rose to prominence in some way or another. That's kind of viewed as a Horatio Alger rags to riches kind of story. Somebody like maybe a Steve Jobs would be a Horatio Alger story. Working in his garage, not a dime to his name, he and Wozniak working trying to get this little Apple computer together, and everybody knows what happened after that. So though a movie about that, about someone inventing something and going through the trials and tribulations and getting it to market, those are that idea, that theme is not patentable. Copyright infringement, you'll see the test is number 4 in section 107 of the Act. And let me find that for you real quick. So you'll see it, and it is on page 320, and it talks about section 107 talks about, it's on that page, 320 talks about the idea that the consideration is the effect of the use of the copyrighted material upon the potential market value of it. So it doesn't have to be identical. The copyright infringement doesn't have to be identical, but if it diminishes the value of the copyrighted item, then you can have an infringement there. Now there are exceptions, and the exception you'll see that on page 320, you'll see the exceptions are the fair use doctrine. It's called the fair use doctrine. And so you can copy certain material, and the one that probably you're most familiar with if you're going to school is the idea of in teaching. I can photocopy sections of books. I can photocopy parts of pamphlets and whatnot and hand them to my students for educational purposes. I can't I can't photocopy the entire book and hand it out. That's clearly and I found too in more recent times that if you go to a Kinko's, or I forget what they're called, maybe they're not called Kinko's anymore, but you go to these copy places, a lot of times they'll refuse to copy certain things if it has a copyright, a little C symbol on the bottom that says copyright in the lower left hand side of the document or wherever. Sometimes they'll refuse to copy it because it's a copyright infringement and a violation of copyright laws, and they could be responsible as well. So also copying things for criticism, or news items, or comments about things that quote or cite or quote things out of a copyrighted material is the fair use doctrine. And so for you all, when you write something, as long as you give credit, if you cite a source, then you really haven't violated a copyright law. So that's the fair use doctrine. And then you have something now called with all this digital, the IP protection on the internet. And so much of what goes on is digital copyrights and digital information which can be copyrighted. This has become so serious that we have moved it not only into the area of civil liability where you can be sued civilly, but there's also some criminal penalties involved as well. So if you pirate a digital information that's copyrighted off the internet, you can be criminally charged. And there are cases, the hackers are probably the biggest ones. They hack in, get a hold of intellectually protected property on the internet, and they end up getting, the federal government and some agencies have hired young people who were formerly hackers themselves, and they can actually trace where this piracy took place and go find the person who did it, find the machines, and then eventually the person who did it. It's an interesting area to read about. So anyway, so Congress passed the Digital Millennium Copyright Act of 1998. And it basically says, and there are criminal and civil penalties against anyone who circumvents encrypted software. Okay, so obviously that's how people protect their software, and they copyright it and they encrypt it, so you can't get in there and copy it and so forth. And so anyone who circumvents it, that is, breaks into it, under the Digital Millennium Copyright Act, 1998, is subject to criminal and civil penalties. Which would be, loss of profit, damage, actual damages, and so on and so on. Okay, we're down to the last one, and I'm going to beat the hour and a half, which will please you, I'm sure. We're down to trade secrets, and of all the ones we talked about, you have the technology aspect that needs protection, but trade secrets is less technical. It's not technology very often. It's usually things that companies have developed in running their business that give them a competitive advantage. I recall when we had our company, we were in the finance and insurance business, and we had a life insurance company, and then we had an agency that provided the products and so forth. And we had banks and savings and loans as our clients, and then we had lesser companies and institutions. And it was not uncommon back then, and this is in the 80s, that you'd get a salesman who would take off with the people he'd been servicing and try to move them to another company or even form his own company. And rarely did we go after them. I mean, I really can't remember when we really went after someone who did that. It was kind of what happened in our business. It was just, okay, that happens. Usually a disgruntled salesperson or what have you. Nowadays, they get sued. And the reason is the whole idea of branding. It's so competitive in most every industry that people have spent a lot of time developing customer lists. It takes a lot. There was years ago we used to say it took 29 calls to get a new client in our industry, to get a new bank or savings and loan, because it took that long to get in and create a relationship and be there at the time when they had a problem and they're letting their other supplier go and you get to step in and take their place. That's a lot, but it certainly, I would think, takes 10 to 15 calls or contacts with them. And so that's money invested. You've got a salesperson out there you're paying, and they're in their car, and you're paying their expenses, and you're probably paying them a small salary of some kind. 10 visits could take a year and a half, and you could spend 20 grand on that person's expenses to try to get you an account. And that guy turns around and gets the account and goes somewhere else. Well, you lost a lot there. And so companies now, I know all the stock brokerage firms are now going after a lot of their stockbrokers who leave and want to take their book of business with them. There are very strict rules now about that, about when they can no longer, and a lot of it's by contract with the brokerage house, where you can't contact a client for 6 months or that sort of thing. Now there's ways to get around that, but what it did was it slowed down the person leaving and trying to take business with them. It slowed them down. It kind of gave them a little caution about whether they were going to jump in the middle of doing something like this, because they might find themselves on the short end of a lawsuit. Because you really don't want to go to court with Smith Barney or J.P. Morgan or one of the big brokerage houses, because they've got a lot more money than you have. So here are some of the things. It's customer lists I talked about. It's pricing. It may be marketing information your company has. It may be production techniques. So there's a whole host of things that are viewed as proprietary. Anything that gives a company an economic advantage can be deemed a trade secret, and anyone who takes that is in effect guilty of a theft, and you can be sued civilly and perhaps criminally, although generally speaking these things would take place civilly. We did have one where one of our senior officers tried to take off and take a big chunk of one of our big accounts, and we went to court for an injunction. And that was the only time that I recall doing that. But by that time, we'd invested so much in the business and so much in our relationships with these banks and savings and loans that we couldn't afford to lose a huge chunk of our business. And so we took legal action. And quite frankly, I led the charge on it. I was furious over it because we had treated this person really well. And they just decided they were going to pull a fast one on us and take off. And They kept telling, once we buried him with legal fees, well, why did you sue me? Why it's costing me so much money? And we said, well, you shouldn't have stolen our trade secrets. If you hadn't stolen them, you wouldn't be getting sued. And we finally drove him into the corner and got a deal. We settled it, of course. You usually settle those things. But we got a deal that was economically and financially beneficial to us. And he got a little bit of what he was trying to steal from us, and it was worth it to get rid of it. But I was pretty incensed about it, particularly the way we had treated this person as a top flight person. He was a senior executive. He was a senior vice president, and so I surely didn't wish him very well after that. Here's how you protect yourself from that as the manager, and that is with a non-disclosure agreement, which we call an NDA, or a confidentiality agreement, and they can both go together. And often do come together, and many times are the same thing, but you'll hear different businesses call them an NDA and sometimes a confidentiality agreement. Now, the NDA, though, tends to be more in early stages when you've got a new device or something, you're talking to people raising money or one thing or another, and you have them sign a non-disclosure agreement. Another one is when companies are buying, when there's a merger or acquisition going on, so they're having to share financial data to look at each other's financials and so forth. Then you'll do an NDA there, a non-disclosure agreement. Confidentiality agreement very often is primarily with employees. And that's the whole idea of trade secrets and anything else that's proprietary in your company. And they agree not to disclose that to anybody. And now what's also gone into those confidentiality agreements, and I started putting them in some years back when I had my business, and that was you could not solicit any of our employees for a year from the time you left the company. That also cut down on people like our senior VP, because in actuality he tried to take about 5 of our people with him. In other words, he was going to just go down the street and open up his own business, and that was the way it was going to be. Well, let me tell you, I scared the living bejesus out of those 5 people, and all it did was buy me time to replace them, because they had already made the emotional separation. He had convinced them that we were a bad company and we weren't fair to anybody, and he was a disgruntled employee, quite what turned out. And they were going to go with him, and let me tell you, they didn't go. At least they didn't go till I wanted them to go, because they had some significant critical functions in the company. I knew their loyalty was gone. I knew they wouldn't stay with the businesses. In a year he'd be there soliciting them, and I just basically put it on them that they were going to find themselves in a lawsuit that they couldn't afford to handle. And then gradually a couple of them actually got religion and stayed, and we were convinced that they had been kind of sold a bill of goods. But one of the key people, one of the real critical people for us, she stayed another year and a half or 2 years, and we found a replacement for her eventually, and she went on down the road. I don't even know if she went back with him, but you can see how that tears the guts out of a business sometimes. Literally can tear the guts out of a business. It can't function if it's a small company. Now we had about 50 or 60 employees, but still, in certain critical areas of your business, you can't afford to lose a person without hopefully planning before it happens. But you can't do anything about it if they just quit. But in any event, clearly this wasn't that case. So anyway, trade secrets. So a couple advices. I get teased about this. I sometimes refer to myself as Uncle Clay. So these are tips from Uncle Clay, and that is, if you have a product or a device and you're raising money or whatnot for it, you do not want to show it to anybody, no matter what they say, without signing an NDA. And if they will not sign an NDA, you want to walk away. There's no trust there. You can't trust them. I don't care what they tell you. I don't care how much money they're offering you. If they won't sign an NDA, they're not to be trusted. It's that simple. Okay? I practiced law for 10 to 15 years, and I've been in the business world for about 20, and I've seen it all. And I can guarantee you, if someone will not sign a non-disclosure agreement to see your new idea, they are not to be trusted. And you just go find somebody else, and there'll be other people you can find. And I'll just extend that a little further, and that is this. In your business lives, if you have your own businesses, and you come across somebody who's got a great idea or deal for you in your business, and you put it down on a piece of paper and they delay signing it, you're going to take it in the shorts. I guarantee it. And what's his name? Men's Warehouse suit store. I guarantee it. If you have an agreement, If you reach an agreement, you're negotiating with somebody, and it's your own business, so your skin's in the game, so to speak. You've got all your money in it. And this person comes, I'm going to bring you this, I'm going to bring you that, you're going to make a lot of money. All you have to do is pay me 120 grand a year, and so forth and so on. And I guarantee you, if he won't sign an agreement that he's going to do what he says he's going to do, he never intended to do it. Okay? He's not to be trusted, and don't sign it, because you will end up losing money and getting hurt. It's that simple. And believe me, I've seen it, and it's happened to me several times before I learned my lesson. Because what happens is you get into that situation and you get into what I call the mating dance. You get all excited and everybody's going to get wealthy and the business is going to grow and all sorts of stuff. And this guy sold you a bill of goods. And believe me, they're out there in droves. And he's seen your business and he's seen an opportunity there. And he's not looking out for the business or you. He's looking out for him, particularly if he won't sign an agreement. So make sure you get that agreement signed. And make sure that agreement has an arbitration and mediation clause in it. Okay, you don't want to go to court, but you want to have a way to get a remedy if this guy turns out to be a complete flake, even after you sign the agreement with him. And by the way, I also believe strongly in my business career, if you have a gut feeling, if your gut says, this is not good, or I've got questions or doubts, trust your gut and walk away. Don't bother. You're going to create a world of heartache for yourself. Even if it doesn't happen, you're going to worry yourself to death for 3 or 4 years while this person's still there. Okay, now, last thing and we're done. And I'm going to make it maybe an hour and a half. Section 7 deals with international protection of intellectual property. And these, believe it or not, these agreements go back to 1883. But the purpose is, as I've said, everything in my mind is driven by economics. And by 1883, countries were interchanging with trade. I mean, they've been doing it for 100 years before that, but trade was taking place more and more so among countries all over the world. The industrialization was taking off in the United States and other parts of the world. And countries suddenly realized that if you wanted to promote economic trade, and you wanted to protect, if I invent something and I want to sell it in Germany, and people are allowed to steal my idea, then why am I going to send it to Germany? So there's going to be no economic growth on this product in Germany unless Germany agrees to respect the patent. And the first agreement is this Paris Agreement of 1883, where it gave protection for patents and trademarks in another country. And 172 countries signed it. Think of that, 172 countries in 1883 signed the Paris Agreement, which in effect gave trademark and patent protection to the one who held the patent or the copyright in 171 other countries. So it gave you some safety, some comfort that there was some legal certainty that you were going to get protected. Now, how well that protection worked could vary from place to place, but at least you had something to hang your hat on. And nothing will kill economic activity faster than uncertainty and unpredictability. And in fact, that's why we're where we are today, because of the government and not knowing what they're going to do with, well, we know now what they want to do with taxes. You don't know what they want to do with regulation. And that is why big business has billions of dollars sitting on the sideline. Until the government can demonstrate that the companies can plan on certain consistent and predictable environments, they're not going to put their money out there. It's just that simple. Because big companies, when they invest $100 million, it's not something you put out $100 million and get your money back in 3 months. It's you put your $100 million back out and you might get your money back in 10 years. Or 6 years or 5 years, but not much sooner than that. So do you want to look out there and invest $100 million and find out the government's going to change all the regulations and whatnot, or go overboard with this green stuff, which results in all kinds of environmental regulations and whatnot, and you can't make a profit on the project you were going to put out? So what do you think you're going to do if you're a CEO of a big company? You're going to hold on to your money until you see where you get a better feeling of where it's going. And at this point in our economy, that's why it's where it is, because big business is completely unsettled about where we're going as a country with respect to economics and business. Business gets beat up real bad. What everybody forgets is that the private sector, and I love that term, and I know I'm on my soapbox a little bit, but the private sector is where revenue comes from. It doesn't come from the public sector. The public sector does not make anything. They don't generate any revenue of any kind. They just take revenue. Okay, and until someone in government recognizes that if you keep killing the gooses that lay the golden egg, there ain't going to be any economy. And we're in for some really nasty times like they are in Europe right now. So as you can see, I'm a little passionate. I'm passionate about that and ADR. But anyway, you've got to have some certainty in economics, and therefore, and economics meaning business and doing business and extending out and spending your money on new equipment, new products, new people, because the next thing you know, you're going to find that I'll give you one last example, and bear with me, because I know I'm getting over the hour and a half. Okay, here's an example. You have Obamacare was passed, all right? And it puts everyone guys that I talk to who are CEOs and CFOs of larger companies, who with employees with over 200, 300 employees, some of them up to 1,000, 2,000 employees. And Obamacare calls for you to meet all these requirements, pay all these additional taxes and fees if you have more than 50 employees. Okay? Now, you've all heard on the radio, I'm sure 100 times, or read in the newspaper, that small business creates the majority of the jobs in our country. Okay? The average company has 5 employees. 5 to 6 employees, the average company, okay, in this country. And they're the ones who hire 1 or 2 workers as the business begins to grow. The companies that have 100, 150 employees, they're the ones that put a new division or product in and hire 3 to 4 to 5 people as it grows, 10, 11, 12 people. Okay? Now, what has the government done with Obamacare? Well, they've used the number 50. If you have less than 50 employees, you don't have to conform with a lot of the regulatory aspects of Obamacare. But more than that, you don't have to pay. You don't have to put in the health plan that's required. You don't have to put it in. And every study shows it's going to be extremely expensive for small business. What do you think small business is doing? They're hiring 49 people. You know, if the government wouldn't figure out that people in private business are not stupid, okay, so what does that do? Well, if you only hire 49 people, guess what? You might have had room for 55 more, for 5 more people to put in your company. You're not going to do it. So there goes your job growth. There goes your job growth. This is my humble opinion. You may have your own. I apologize for getting all fired up about it, but to me, it's just ludicrous. And the Philadelphia Stock Exchange was in Philadelphia County, and it was located a street a block away from Montgomery County. And the city of Philadelphia, this is the government, right? The bureaucrats decided they were going to impose a tax on the Philadelphia Stock Exchange to raise revenue for their city. And Philadelphia Stock Exchange said, don't do that. And the city said, you know what? Too bad, you're here. You know what they did? They moved across the street. They moved to Montgomery County. Okay? There went the tax. All right? That's why all the businesses are leaving California, because they're not going to pay these incredible taxes that they're throwing on us. Anyway, there won't be any questions on that. And I apologize for getting fired up. I'm assuming I have an audience, even though it might only be 10 of you or 8 of you, but in any event. Okay, let's move on, and I'll close. I promise. I'm going to be about 5 minutes over. So we've got these international protection statutes for intellectual property, and you can see why they're important. So you get trademark and patent protection in 1883. In 1886, you get the Berne Convention, okay? And what was that one? It added copyrights. So now you had trademarks, you had patents, and now you have copyrights. That one was signed by 170 countries. Okay, so here you are protecting authors and writers and people who put movies. And what does that do? Now you can sell the movies abroad. You can sell books in other countries. They're not going to be knocking them off or reprinting them and paying you nothing. Okay, economics. It creates a sense of certainty and comfort that you're going to get repaid, or you're going to be paid for your hard work and your creativity and whatnot, because the 170 companies realize that they've got the same issues in terms of selling their books and whatever in other parts of the world. All right, and then lastly, you have, or not lastly, you have the TRIPS agreement. This is an acronym, and that's all I care that you know is the TRIPS agreement. In 1994, that was signed by 100 countries, and the whole idea here was to standardize the patent and trademark laws because different countries have different trademark, patent, and copyright laws, and so the idea was to try to standardize them enough that you could level the playing field. What's the purpose? Again, it's certainty. Again, it's predictability. It's the kind of creating an environment, or trying to, in all the countries, that you are okay then with getting into economic relationships with people in other countries because you're going to get what you're entitled to in the cost of what you're selling. Okay, so that's the TRIPS agreement. So Paris Agreement, 1883, patents, trademarks. Berne Convention, 1886, that's copyrights. And the TRIPS Agreement in 1994 was an attempt to standardize the laws in copyrights, trademarks, and patents so that you had a level playing field. That is, you weren't going to go into Belgium and find out that they've got a copyright law that gives you no protection. Okay. And then last but not least, the Madrid Protocol, which is current, 2003. And that's more of an administrative kind of thing, because what used to happen to companies is if I wanted to file a copyright, or let's say a patent for a piece of equipment, I had to go make that patent application in every country I was going to put the product in. So you can imagine the time, expense, lawyers, engineers, people doing drawings, every single country you wanted to go into. Under the Madrid Protocol, 79 industrial countries signed it, 79, and what it calls for is one filing. You file your patent application one time, and it's recognized all over the world. So you file your patent application in the U.S. Patent Office, and 78 other countries have said we'll recognize that as a legal, legitimate patent, and we'll respect it. So that is those are the four major agreements when you talk about international protection of intellectual property. Okay, the Paris Agreement, the Berne Convention, the TRIPS Agreement, and the Madrid Protocol. So just kind of know what they're about, and it's pretty simple. Okay, so that is it. I went over by 6 minutes and 53 seconds. I don't know what it's going to say when you pull it up, because it's going to take me a second to put my papers together and look and see if there's anything else I want to tell you about. But again, please try to get those proposals in so I can see them. I'll get them back to you as quickly as I can next day or that day if it's at all possible, because I don't want to take time from you on getting those together. And also I'll get working on the quiz as quickly as I can. And I think if that's a huge problem to put it out on Thursday and get it to you and give you until next Wednesday, I'll try to understand if someone's got a trip or something. But I'd like to try to do that if you guys can work with me on that, because it's my fault, it's my responsibility. But I just, like you, I've gotten hit with so many things. I'm sure you may go into your boss this week and plead for a couple more days on something. So be compassionate for your old professor here. That will do it for us today, and I will look forward to seeing everything you send in or sent in last night. I haven't looked at it yet, but I will very shortly. So you'll have a great week, and I'll see you next week.